This is case number 24CR41416, the State of Ohio versus Aaron Jones. Mr. Jones is present before the court with counsel, Ms. Morton. Mr. Arnold's here on behalf of the State of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you
3
won't.
years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life, and you never know how good you might be in different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. Had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry.
Cool.
It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I got to do.
Ms. Martin does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man.
Welcome back, everyone. Today's video takes us straight into Judge O'Donnell's courtroom for a case that has everything: a repeat offender, a check scam, excuses stacked higher than a Jenga tower, and a judge who's not here to play games. The defendant, Mr. Bazowski, has been down this road before. Probation, rehab, second chances, you name it. He's had it. But this time, he's up against a judge who sees straight through the stories. Watch closely, because you're about to see how a scammer tries to lie his way out of trouble, only to get boxed in by the sharpest questions a judge could throw. And trust me, the ending? One of the most satisfying smackdowns you'll ever see in a courtroom.
The jury and everything that you do, here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
And that's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so, I mean, that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I'll
Are you
understand
aware
the
of any?
question.
Are you aware of any?
Here we go. The defense attorney is playing the sympathy card. Addiction, bad choices, community control, treatment center beds. It's all laid out to make his client sound redeemable. But let's be real. This isn't his first rodeo. Judges remember patterns, and the word probation violation shows up way too often in this guy's history. The defense is practically begging, give him another shot, and if he blows it, well, prison is waiting. But Judge O'Donnell? He knows giving a scammer another chance is like handing a pyromaniac a
Defense, I assume, at
Correct.
least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand
Correct.
that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man.
I'm
That's
sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
And here comes the first real clash. The defendant says he's capable of success, that he can stay sober, that he'll finally make the right decisions. The judge cuts him off with a dagger of a question. Then why haven't you? That's the turning point. O'Donnell doesn't want promises. He wants proof. The defendant starts scrambling, talking about people he cut out of his life, old girlfriends, bad influences. But notice what he doesn't mention. Actual accountability for the scam itself. That's the red flag.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you.
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
You will be required by law to follow the Ohio Rules of Evidence and the Ohio Rules of Criminal Procedure. Do you understand that?
Yes, sir.
Your lack of knowledge of the evidentiary and procedural rules will not prevent this court from enforcing those rules. Do you understand that?
Yes, sir.
You would understand that your lack of knowledge regarding the rules of evidence and the rules of procedure will result in you waiving the review of those issues on appeal. You understand that?
Yes, sir.
If you have any difficulty in presenting a defense on your own behalf, any difficulty in complying with the procedural rules or the rules of evidence, the court cannot assist you in the presentation of your case in any way. Do you understand that?
Yes, sir.
You understand that the state of Ohio will be represented by an experienced trial attorney.
Yes, sir.
You understand that your right to represent yourself is not a license to abuse the dignity of this courtroom, and thus, if any disruptions during the trial occur, your right of self-representation may be vacated by me.
Now this is where it gets messy. He claims he found a random bag with a checkbook at a job site. But which job site exactly? First it's Midburg Heights, then Wickliffe, maybe Fairview. He changes cities like someone flipping channels. That's a big no-no in court because judges are trained to spot inconsistencies. And here's the kicker. He says he sat on the bag for months before suddenly rummaging through it and deciding to try his luck. What normal person finds a bag of checks and just keeps it in their car? Yeah, exactly. The story is falling.
Understand that?
Yes, sir.
If you choose to represent yourself when you're convicted, you cannot complain about the quality of your own defense, and it will be basically a waiver of your right to appeal the ineffective assistance of counsel. Do you understand that?
Yes, sir.
Do you suffer from any physical or mental disease or disability?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Has anyone threatened you or forced you in any way to waive your right to counsel?
No, sir.
Have you been promised anything in exchange for your right to counsel?
No, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
Is comedy gold. The defendant actually claims he thought forging checks would only hurt his credit score. Imagine walking into court and saying, I only committed fraud because I thought it'd ding my credit like missing a car payment. Judges have heard every excuse in the book, but this one's going straight into the Hall of Fame. And you can see the judge's face. Pure disbelief, mixed with a touch of, do you really expect me to buy that? The defendant just downgraded himself from scammer to amateur comedian.
Out next.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your
So
security of this.
how I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's
Now the lies catch up fast. Judge O'Donnell zeroes in on a specific check made out to Constance Wagner. The defendant stumbles, then admits it was another forged check. The judge presses further. So, when you cashed it, did you claim you were Constance Wagner? And boom, the scammer admits it. He literally impersonated a woman at a check cashing place. At this point, his own lawyer is basically pleading with him. Just tell the truth already. Because every lie that comes out only makes the sentence worse.